Good morning, everybody. Thank you all for joining us. We've got a few people hung up in the waiting room, but I think I'm going to go ahead and get started with our Zoom housekeeping items anyways. And I'm going to start by reminding you, as I always do, that your Zoom toolbar is probably at the bottom of your screen, depending on what kind of device that you're using. It might be flashing right now because I just put a message into the chat. And you can use the Zoom toolbar to find buttons like start and stop video or mute and unmute. We do ask that you stay muted during the Q&A unless you want to unmute yourself to ask a question. That just cuts down on background noise and makes it easier for everybody to hear. We also don't mind if you want to stay off camera, and we'll remind you to be mindful if you keep your camera on, just so that you don't, I don't know what people might do on camera that they don't want to do on camera, but just keep in mind if you've got your camera on that you should, there you go. That's exactly right, Jan. You can do that. We give you permission. Anyway, so Zoom toolbar, the chat that I just mentioned where I put in the message is the best way to ask questions during the Q&A or to ask us to clarify something that we've said. The flip side of that is we don't want you using the chat to get into arguments with each other or discussions about the issues that we talk about today. Those kinds of conversations are better left for things like the CAI message boards. And I know that you guys are all well behaved in the chat, and this is probably almost not necessary for me to say anymore, but we just like to give everybody the reminder. The other thing that we do remind you about every week is that we are here to give general information only, not to give legal advice. So we were actually just chatting before we started the Q&A today about some of the questions that we had to politely decline to answer this week, where people were sending us paragraphs of very, very specific information about their specific community and asking really specific questions. I might be overusing the word specific, but I think you guys all get that I'm trying to make a point. When the questions that you send us are ultra specific like that, or very, very detailed like that, or if you're copying and pasting sections of your particular governing documents, those are questions that are almost always impossible for us to answer in this context because we can't give legal advice here. So we try when we can and when we think it's a helpful topic to at least try to touch on the topic generally rather than just declining to answer those questions altogether. But sometimes they are just too specific for us to cover. And when you get an email back from Chelsea saying this is too specific because it asks for legal advice, that's not her call, that's my call. So if that annoys you, you can direct your annoyance at me and not at Chelsea. And either you can try to reword the question to make it more general, but more likely you need to submit it to your association attorney and ask for legal advice. One of the things we actually were also even chatting about before is that sometimes we know that those questions come from board members that are clients of our law firm, and that it always concerns us when we email back and we say, this is really too specific, you should ask your association attorney. And then we don't get that question back from our client, from the person that we know is one of our client board members. So if you have a lawyer in a forum like this that's telling you you need to get legal advice from your association attorney, take that to heart. Really consider taking it back to your board, getting authorization to submit the question to your attorney. If you are a community that does not yet have a law firm, I urge you to get that handled, establish an attorney-client relationship with a law firm that you trust in this practice area now, when you don't need one, when you're not in crisis, so that when you get served with a lawsuit, as just happened with a client that's now sort of panicking and sending us all the documents to get started as a client with our firm, because they got served with a lawsuit that was filed against them by a homeowner and they've got 20 days to respond. Don't put yourself in the position of not having that attorney-client relationship when a crisis strikes. Instead, get that established ahead of time so that you have somebody to call when things like that happen. We have also been reminding everybody every week about the Corporate Transparency Act, which currently is still set to take effect in January of next year. It is still being challenged nationally on a number of different fronts, and we're still telling our clients that it's reasonable to continue waiting to take steps towards compliance, maybe for another month or so before they start moving towards compliance. And another thing that we will remind folks about, as that date does get closer, if it is not, blocked or delayed implementation, is that one of the primary concerns that we hear from a lot of board members is not wanting to give their personal identifiable information to their association. Board members can individually go to, I think it's the FinCEN website, and sign up for their own individual ID, where you are just giving the government your information. Spoiler alert, they have it already. And then you get a unique identifier for you as an individual, which you then can give to your association, and they can use that number in place of your personal identifiable information on the association's application to comply with the CTA. So that is one way to comply without the concern of giving, your driver's license number or other information like that to your association. So that's a possibility to keep in mind. Go ahead,
and
Katie.
If you are a TSA pre-check user or global entry, it's again, they already have it, but you can almost use that number just to get the FinCEN number. So it's a lot less work. So just a plug for anyone who has TSA pre-check.
That's great. I did not know that you could use that. That's fantastic. All right. We have also been reminding you guys that CA Day is coming up. It's on October 5th. So it's only a few weeks away right now. And I don't think we've mentioned this before, but Ken and Katie are co-presenting on a topic called What You Must Do or Can't Do When WUCIOA is Your Statute. And I'm also going to be co-presenting with Christelle Perkey, who is the WSCAI lobbyist, along with Hillary, who is the LAC chairwoman. And we're going to be doing a 2024 legislative update. So we hope that you'll come see us. We're going to have a booth there. We actually just, I think WSCAI posted on their LinkedIn page our booth number. So if you want to write that down and come find us at the event, we would love to see you all there. And for anybody that's like, what the heck is CA Day? Who's WSCAI? If you go to WSCAI.org, that's the website for the Washington State Community Associations Institute, which is an educational and advocacy-based organization that advocates for community associations, for the people who live within them, and that brings together all the different types of vendors that serve community associations. And CA Day is an annual conference at the Downtown Convention Center where various professionals that serve community associations, including lawyers, reserve study professionals, managers, insurance professionals, you name it, will be hosting booths, but also providing educational seminars and topics for people to learn from within this world, I guess. So we hope that we will see you there. And without further ado, I think I'm just going to go ahead and jump right into the questions. And again, if you have additional questions that you would like us to answer, put those into the chat. I think we'll probably have time for maybe a couple questions at the end today. So here's our first question. Is there a statute of limitations on HOA liens? If an association forgets to release a lien after a delinquent account was paid off, and it was discovered many years later after lien costs have increased significantly, who is responsible for the cost of the lien release? The short answer to this question is the association is. In this particular scenario, where the balance due was paid in full, if the debt has been paid, the lien should be released. And if you didn't release it at the time of payment in full, then you should do so when it is discovered, and it should be done at the association's cost. That is not obviously probably the answer many people might want to hear, but that is what I think the reality is. As far as the statute of limitations part of this question is concerned, there is no specific statute directly on point when it comes to like a time when a lien quote unquote expires or when a lien release has to have been recorded. There is a statute of limitations when it comes to collecting unpaid assessments. And I do think as a related issue, it is worth mentioning that when you record a lien, that does not stop the statute of limitations from operating against your ability to collect older amounts due. In other words, we have a lot of clients that think all I have to do is record a lien and that will protect our HOA's ability forever to collect the balance due. And whether the owner sells in 2 years or 10 years, this lien will mean that we get paid in full when the property is sold. That's not how it works. The only thing that can stop the statute of limitations preventing the collection of older amounts due from preventing the collection of older amounts due is filing a lawsuit, either a lawsuit to foreclose the lien or a lawsuit for a personal judgment against the owner that owes the association that money. As far as what that statute of limitations is, for condo associations, it's 3 years. For HOAs governed by the HOA Act or communities governed by WUCIOA, the statute of limitations is 6 years. That means that if any of the balance due becomes older than either 3 years or 6 years, and in 2028, it'll be 6 years for everybody, then you lose the ability to collect it regardless of whether you have a lien recorded. So don't make the mistake of thinking that recording a lien preserves your ability to collect, notwithstanding the statute of limitations. I will say there is one exception to my answer to this question about releasing a lien, but it's in a different scenario than the one posed by the question. So if a property is foreclosed by the bank and the association has a lien recorded against the property, so we're not talking about an owner pays in full scenario, the bank foreclosure essentially wipes out that lien, right? It makes it what I would say is procedurally invalid. And in that scenario, in particular, because you haven't gotten paid in full, or if you don't get paid in full, it may not be necessary to release a lien from a legal perspective. However, if and when the now current owner, the next owner, decides they want to sell the property, whether it's the bank or a third party that purchased it at the auction, the title company is almost certainly going to require that a lien release be recorded anyways, even though that lien is no longer effective, okay? And in that scenario, I think it might be reasonable to request that the seller in that scenario, the new owner, reimburse the association for the cost of the lien release, because you as an association are recording a lien release that may not be legally required, but the title company wants it. And so it's essentially for the convenience of that new owner / seller. So that's a scenario where it might be reasonable to ask them to reimburse you for the cost. There's a lot more that I could say about this question. And, one thing I will offer is, as an example, when our law firm gets involved to help one of our clients collect unpaid assessments from a homeowner, we always include in the amount that we ask the owner to pay the cost of the future lien release against the property. And so when we collect in full, that we just automatically release the lien, and the association isn't the one eating the cost of that because we've built it into the balance due by the homeowner. So this is something that you all can be aware of, whether it's your management company that's giving a payoff amount or the board that's giving a payoff amount directly. If you keep in mind the existence of a lien and the need to be reimbursed for the cost of releasing it, and add that amount to whatever payoff you're issuing, then you won't be left in this scenario. I think that's all I need to cover for that question, but Katie, if you have anything to add, please jump in.
Nope. So I'll just go to the next one, which is the association had a request for the board. There was a tie. Per the association CC&Rs, there's no tie resolution. How is this handled? There's a second part to this question, but I'm going to answer the first part and then read the second question. Basically, if there's a tie, the action fails. That's if an action needs approval of a majority of the board or a majority of the association members. If you have a tie, that's not a majority, and so the action does not proceed. The board can try a vote again if it's just the board and maybe campaign to get people to change their mind, or they can choose that it's not worth it and they can drop it. But basically, if you need a majority, 50% is not a majority, and so it doesn't pass. The second part of this question is if an association has a position that is not in the association's documents, a member at large, this is not a legitimate board position, correct? This position has been in process for years before our current management. We can't answer this question fully without looking at the governing documents, but I will say there is a difference between board members and officers. So your bylaws may say president, vice president, secretary, treasurer, but require that the board seats 5 people. This means that there would be a member at large. Also, a person can be elected to the board without serving as an officer at all. Say someone is doing 2 officer positions and someone's just elected to the board. They would be a member at large. Your documents may not say that people can be a member at large, but they are elected to the board and they can serve without having an officer position. So this would, another example would be, say your documents only had 3 officer positions, treasurer, president, and secretary, but you have a board of 5. 5 people are elected, 2 people would be members at large. If your goal is to remove a member because the documents don't support the extra position, so say you have 4 board members, but your documents only provide for 3, you may still have to allow this person to serve until the expiration of their term if they were elected by the board members. And at that point, we recommend you talk to your association attorney about how to best proceed. Valerie, anything to add?
Nope, I think you covered it. Thanks, Katie. All right, here's our next question. Our HOA charter from the city of Bellevue specifies no on-street parking in our 3-block long complex with only 1 access point and 4 cul-de-sacs. The reason for the requirement is that our roadway is narrow and emergency vehicles need space. The policy is stated in the rules and regulations and fines are specified, yet it happens all the time because there is no separate parking area, only owners' driveways and garages. Occasionally an owner complains, but policing on a regular basis is just not possible. The city has suggested that we could paint all of our curbs red, but we are in agreement that would be an eyesore. By not enforcing, are we at risk in any way? I want to start by saying this question is too specific, and there's also too much that we don't know in order to be able to answer this question for any specific community. We would need to know whether the streets are public or private, and we would need to see the governing documents that you're talking about. And we also think probably the charter isn't from the city of Bellevue. Maybe you're talking about your CC&Rs instead. I'm not exactly sure. So this is both too specific and also not specific enough for us to be able to give an answer. But even if you gave us all that information, we couldn't answer anyways, because then it would be legal advice. So we can talk about this super generally. And as a starting point, if something is required for safety, how it looks is irrelevant. So if the city comes back to you and tells you that you need to paint the curbs red, then you got to paint the curbs red, even if you think it's an eyesore. There are fire code provisions for painting fire lanes red, and there's a good chance that you might now be required to paint them and to post very specific signs. And to your question in the last sentence, which says, by not enforcing, are we at risk in any way? This speaks directly to the question of risk. If you have your curbs painted properly, consistent with the statutes or the fire codes, and you have the proper signage that is required also by the fire code, that means you're shifting at least some of the risk here from the association to the people who are choosing to park their cars in violation of the red curbs and the posted signage. If the roads are maintained by the city, then the city can enforce the parking restrictions, or might, maybe they would even be the ones to paint the curb. The association cannot find violations that it doesn't know about. And I don't think that you have an affirmative obligation to, be on a every hour, every 2-hour schedule out there looking for cars parked in violation. But if you receive complaints of parking violations, I think the board has a duty to investigate those complaints and determine if a violation has occurred. And, again, as to the question of risk, here's the scenario that we think of. And this is we're teaching you how to think like lawyers, at least in part, when we do these Q&As. If there were to be some kind of incident, like a fire, for example, and there was a car or cars parked in violation, and those were the proximate cause of some injury to a person, meaning the fact that those cars were there delayed the emergency response in some way and somebody got injured. And if the association knew about that and took no action of any kind to enforce, then there could be some kind of risk, right? The other thing that's worth mentioning, and this is maybe something you pass on to your owners who the repeat offenders as far as this parking situation. If their car is parked between, for example, where a fire truck and a hydrant might go, the fire department will literally put holes in the windows of that car to run the hose through the vehicle so that they can connect to the fire hydrant and respond to the emergency that's happening. So there's risk to the association, sure, or there could be in a certain scenario if you know about a hazardous situation and you fail to respond to it appropriately. There's also risk to the owner's property or the people who are parking their cars there because of what could happen in a scenario like that. I think one of the constant balancing acts a board does, in scenarios like this and many, many others is balancing enforcement against risk, right? And one of the things we always remind our board member clients about is that you have to be reasonable in your approach to this balancing equation. And you also have to, as a board, comply with the duty of care that is imposed upon board members in Washington state. The other thing is you do specifically purchase insurance to deal with many, many different kinds of risk, including this particular type. You would have a general liability policy that could protect the association if risk arose in a scenario like this. So that's not a very specific answer to your question, but it gives you food for thought as you, as a board, kind of determine how best to handle scenarios like this. But if you're, I mean, it sounds like this particular community is actually dealing with this scenario. And if you were my client, I would tell you, you should email me this question so I can write you a memo and help you balance these enforcement versus risk kind of questions and give you advice. Part of why it's so important to consult with your attorney when you're making these decisions is because, number one, it helps you meet your duty of care, your duty to investigate, rely on objective information, etc., your duty of care as board members. And number two, if your attorney gives you specific advice and you rely on that advice, that does some shifting of risk as well to the law firm. If we mess up, if we give bad advice and it leads to a bad outcome for a client, thankfully, knock on wood, I need to find some. That doesn't happen often, but that is part of why we tell our clients to do this, because it does shift some of that risk to the law firm instead of to the association. And there's a benefit to that. Katie, did you have anything you wanted to add?
No, you covered it. So our next question is, did condo law make any recommendations to amend resale certificate documents following the collapse of the Champlain Towers in Surfside, Florida in June of 2021, specifically relating to structural soundness type questions? The short answer is no, we haven't made a recommendation, but we'll get into more details. We did work with some associations to respond to changes in documentation that banks required to fund loans for owners. So we understand that Fannie Mae and Freddie Mac have some specific questions about structural integrity, which would not apply to most condos because of their short height. Remember, the Champlain Towers were like 20 stories tall. So not many of the buildings out here are that tall unless you're in a downtown area. But we haven't made any specific recommendations unless required by statute or federal law. Other states, like Florida, did update their resale certificate and disclosure requirements after the collapse. To our knowledge, Washington has not made a requirement yet. We recommend using the statute for resale certificates as a checklist as for what needs to be provided in a resale certificate. That way you know what you need to disclose and you are complying with the statutory requirements. The RCW 6490-640 is the WUCIOA resale certificate statute, and RCW 6434-425 is the resale certificate statute for condos. There is no resale certificate requirement for HOAs under 6438, but in 2028, you will have to provide one. And in terms of structural soundness and whatnot, 6490-640 subsection 1G does require a statement whether or not the association has a reserve study that's been prepared in accordance with the reserve study requirements. And that's probably the closest it gets to dealing with structural soundness. Basically, our legislature has decided that owners at least need to be told what is going on in their community and how the buildings are. So potential buyers need to know if there are reserve components failing, when things need to be replaced. And so that's the reserve study requirement and why it's included in the resale certificate. Anything to add, Valerie?
Yeah, I think it's worth noting that RCW 6490-640, so this is for WUCIOA communities, they added in the last few years a specific statement that you have to include in your resale certificate if you do not have a current reserve study. And this is the statement. This association does not have a current reserve study. the lack of a current reserve study poses certain risks to you, the purchaser. Insufficient reserves may, under some circumstances, require you to pay on demand as a special assessment your share of common expenses for the cost of major maintenance, repair, or replacement of a common element. And I know that speaks more to the risk of a special assessment than it does to a building collapse, but deferred maintenance is the concern here and was one of the significant factors that led to the Surfside building collapse. And so I think this is a really beneficial addition to the statute and to the resale certificate requirement. I'm actually really glad that the resale certificate requirement is going to apply to all common interest communities in Washington starting in 2028. And as we'll see in a later question, talking about deferred maintenance and failure to increase assessment and fund, necessary repairs, the risk of not having a reserve study and then, of course, not complying with the reserve study when it comes to funding is very real and can lead to pretty significant hardship for your homeowners. And it doesn't have to be a building collapse like the Surfside building collapse in order for that to be significant and a negative, impact to your owners. So even though our recommendations haven't changed because our statutes haven't changed, the whole point of a of a reserve study is to be keeping tabs on the condition of the buildings, the condition of all of the different components that the association has to maintain and repair and replace, and be proactive about that so that you don't get to the point of having, a foundation crack or a building collapse or a more serious situation like the one in Surfside. So I think that's all I have to add. Did you want to say anything else on that? Okay.
Oh, good.
All right, here's our next question. What can a homeowner do if the board president refuses to provide invoices on work done on the common areas to the homeowners to review? I put in a request 20 days ago. So I'm going to just start right off the bat and say this is too specific for us to answer. So I'm not going to answer this question for you. And if you want somebody to give you an answer for your specific situation, then you need to go hire an attorney and ask them this question, okay? So I'm going to talk generally about records and timing and owner right to review, but this is not legal advice for your specific situation. I will say that generally invoices for work performed are records of the association that an owner would have the right to inspect. That's part of your financial records as an association. Owners have the right to inspect financial records. There are certain scenarios in which an association could be permitted to withhold disclosure. And I don't know if that kind of scenario or exception might exist in your case. And I'm not going to speculate about that, but it's important to note that the owner right to review records is not absolute and unqualified. There are statutes about the records that an association must maintain and an owner's right to review them, but WUCIOA is the most specific of them. And under RCW 6490-495, subsection 2A2, whatever, requested records must be provided within 10 days, but no more than 21 days unless approved by a court. I do think that as an aside, there's a really big difference between when an owner, I've had an owner contact me and demand to review 10 years of every association record. What's reasonable in terms of a response time for a voluminous records request like that versus, can I please see the last 3 months worth of landscaping invoices? Those are very different, right? And a reasonable response time is different given the type of records request that an association is dealing with. I think it's important to point out that this particular section of WUCIOA does not apply to non-WUCIOA communities. So the 21 days is not a requirement for every community in Washington state, but it's a reasonable guidance that associations can use when determining what their turnaround time might be. I also think that it's worth pointing out and reminding everybody that no board member can act alone. So you might have submitted this request to the board president, but the board president doesn't get to decide whether to turn over that invoice and how the response might look from the association. The right procedure for the board member to follow is to then forward the request to the full board, maybe add it to the agenda for the next board meeting, and determine as a group how to respond to an owner request to review records. And The most frequently a board might meet is once a month, and most communities don't even have monthly board meetings. But even if they do, if your request came in, 5 days after the last board meeting and the next one isn't for 3.5 weeks, then 20 days might not be unreasonable. Remember that no board member can act alone. So the board president can't just decide to turn those invoices over to you without taking the question to the full board. As to the question of what you can do if your board is not allowing owners to review records as requested, owners can collectively require a special meeting and can ask for a board member to be recalled. There's a procedure that you have to follow for that in the statutes, and so you would want to look that up. And also, if a board member fails to comply with the statutes or the governing documents, you can sue them. You can use the courts to force compliance, but you would also want to look at the governing documents for your specific community to see if there is a dispute resolution provision, such as like a mediation or arbitration requirement, which you have to follow before you're allowed to take something to court. And, this is sort of where I end on a question like this, is you have to decide how important it is to you to see those invoices, because litigating anything is expensive, right? The cost of just having an attorney draft, file, and serve a lawsuit for you in a scenario like this is probably, I don't know, $3,000 to $5,000 at minimum. So how badly do you want to see those invoices? That's part of the question. But I wouldn't assume that just because it's been 20 days since you submitted the request that the response is improper. And I think this at least gives you a framework for what that response timeline might look like and what your options might be if there is not a response in a longer period of time. Did you want to add anything to that, Katie?
The only thing I'd add is most records don't need to be kept forever. So for example, financial records only need to be maintained for 7 years. So, and I'm not that specific to this question, but if you're asking for the tax return from 2010, the association may not even have it. So, I mean, meeting minutes, they're an exception. They need to be kept, but some things only need to be the current document or kept for 7 years. So keep that in mind when you're asking for something. If you're asking for 10 years of financial records, you may not get 10 years of financial records. It doesn't mean that they're being shady. It's just they don't have to keep it under the statute.
Right.
Okay, the next question. After the membership votes and approves numerous individual cleanup amendments to the declaration, can the board choose to record a restatement of the declaration that incorporates those amendments? Short answer is probably not, but we don't have enough information to answer this question fully. We would need to see the language of the amendments to give advice. Basically, the board alone cannot choose to restate the declaration by adding the amendments. They can present to the owners a restated declaration that incorporates all the changes and ask the members to approve that. Generally, for amendments to be valid when recorded, owners need to be presented with the actual language to vote on. So if you're removing things that even if they'd already been voted to remove just to clean it up, that should still be presented to the owners, and then the board can record the amendment. And we recommend consulting with your association attorney to make sure that you can have a valid amendment when you record it or restatement. Valerie, do you have anything to add, or else I'll just jump in? Okay, they're jumping back to the question about the records. There's a question of, is there a list of how long some records need to be kept? The answer is yes. The record statute for every statute says how long each record needs to be requested. So if you just Google records and your governing statute, it will pull up the list. And I'm going through some records right now and I'm actually using it as a checklist to determine if some records need to be kept or not. And Valerie has put it in the chat. All right, our next question. If the bylaws require that the board get membership approval to spend more than a few $1,000s for a single expenditure, and that makes it difficult to repair and replace reserve components, do you recommend amending that bylaw? If so, for best practice, what should a bylaw about board spending contain? So this again is a really specific question where we need to see your documents, but it is likely that you do not need owner approval to pay for reserve components from the reserve account. Again, we need to see the specific language in your documents, but typically you do not need owner approval to spend reserve funds on reserve components. You likely do need approval to spend money over a certain amount for a capital addition or improvement. This does not include reserve component repair or replacement. It would be like installing a pool that you don't already have, not repairing a roof that is a reserve component. So generally, the board has the authority to use reserve on reserve components without owner approval. If you're taking reserve funds for non-reserve expenses, that may need owner approval. That's a whole different statute and question. If you're doing a capital addition over a certain amount, that usually needs owner approval. But again, we would need to see your documents to say what is appropriate. We would also need to see your documents to say what an amendment to the declaration, what that should contain. It's usually not an amendment to the bylaws unless your bylaws include this kind of provision, which they shouldn't. This should be authority provided in the declaration, and it should be an amendment to the declaration. It is common for declarations to be amended to give the board more spending authority or borrowing authority. But again, we can't answer it specifically for you and what it should contain because you may not need to do anything depending on what's written. Also, just as an aside, look in your documents for language about inflationary increases. Sometimes they're in the front, sometimes they're in the back, but this usually allows any dollar amount set in the declaration to be adjusted for inflation. So what may be $5,000 require spending $5,000 require owner approval back in 1970 is actually like 20 grand now. And I don't actually know if that's what it is, but that's the example. It can significantly increase a board's ability to spend without owner approval, and it's already provided in your declaration. Anything to add, Valerie?
Nope, I think you covered it. Thanks, Katie. All right, here's our next question. Out of our 65 units, I believe we are well over a dozen that are rental units. A few of the units have multiple renters. 2 questions. Does adopting a revised cap on renters require a vote from the homeowners? And 2, what are the governing rules for homeowners renting out individual rooms within their unit? So, amending an existing rental cap or adopting a new rental cap requires an amendment to the declaration and approval by the homeowners. The owners need to be given the text of the proposed amendment in advance of the meeting at which you vote on the amendment. And once you have the required percentage of owners voting in support of the amendment, then the board executes the amendment and it needs to be recorded with the county. And only then does it take effect. If you were to amend or adopt a new rental cap, we would also tell you that once it is recorded, you should send a copy of it out to the owners and notify them that the amendment is now in effect. Your declaration might have language regarding renting out individual homes or rooms within a unit, but the legislature probably prevents the enforcement of that language at this point. So the city of Seattle specifically allows tenants to add roommates. And there's recent legislation that took place outside of the city of Seattle at the state level that now prohibits any community associations from imposing occupancy limits among unrelated adults, basically. So you can't prevent an owner from, in particular, if the owner is living within the unit, they could rent every single bedroom that they have out to somebody else, and you can't prevent that. Under every governing statute for common interest communities in Washington state, there is a prohibition on rules and restrictions, like I said, that limit or regulate the number of unrelated adults that occupy a unit. The only exception to that is if there is, for example, some sort of local building code limitation, your community could attempt to enforce that kind of limitation on occupancy within the community. But I would tell you to be very cautious about that and absolutely tell you you should consult with your association attorney before taking any steps to do that. Most of our clients, when we are drafting rental caps for them, will specifically define what a renter is, who's a tenant and who's not a tenant, and when is a unit a rental and when is it not a rental. So for example, most of our clients will include some sort of exemption for family members. So if I own my unit and then I rent it to my parents or to my kid, that would still be considered an owner occupied unit under these particular types of definitions. Also, by the same token, if I live in my unit and I've got 3 bedrooms and I rent out 2 of the other bedrooms to unrelated adults, because I still live in the unit, my unit is not a rental. So you do have, as long as you don't run afoul of the types of restrictions that I mentioned already, statutory both at the state level or the city level, as long as you don't run afoul of any of those limitations, you have some flexibility in how you define a rental and can deal with some of this question in that way by, putting those definitions in your amendment. What are the governing rules for homeowners renting out individual rooms in their unit? I think I've already covered that part of the question. And, I'm going to jump ahead really quickly, Katie, to question number 10, because this is directly related to the same question, which is, are there statutes in place regarding family members living in a unit rent-free and how this might affect a rental cap in a condo? So as you might suspect after what I just said, you get to define this with your declaration amendment, with your rental cap language in your declaration amendment. So if the declaration is silent on this, there isn't really a definition. There's no statutory definition. And this is true regardless of whether rent is paid. So whether my parents live in the unit rent-free or whether my parents live in the unit with a lease and they pay me rent, there isn't a statutory definition that says when that is or isn't a rental, but the declaration can define that when you impose a rental cap in an amendment to the declaration. So you can decide in your community that rentals to immediate family members, whether they are rent-free or not, are not rentals for the purpose of a rental cap. The banking industry also doesn't define what a rental is. And this is the sort of the scenario in which the question of your rental percentage comes up the most often, is when a lender is looking at whether they want to back a mortgage within a community that has, 60% rentals, for example. There isn't a statute or a rule out there that says you can't get a loan in a community that is more than X percentage of, rented units. But this is the standard, or the scenario in which the question does come up the most often. I think it's also worth pointing out that one thing you want to be careful of, especially if FHA certification is important to your community, is that if you impose a rental cap that limits the percentage of units that can be rented at any time, that can disqualify your community from being FHA certified. So if having that kind of certification is important to your community, you want to consult with your association attorney and understand what kind of language you could or could not have in your rental cap when it comes to those percentages. So I think that covers both of those rental related questions. Did you have anything to add, Katie?
Yeah, the only thing I'll add is it's going back to occupancy limits. And because usually when we talk about this, the follow-up question is a lot of research into your city ordinance or your county ordinance or HUD guidance on occupancy limits and what they say. The occupancy guidelines, at least from HUD, are a lot more generous than what you may think would be reasonable to number of people living in a unit of your size. I'm not going to get into the specifics of exactly what it is, but it is usually more generous than what you are thinking. And all of that is boiling down. We are in a place in our state, in our major cities, and in our country of a huge housing crisis. And all of these guidelines are engaged in trying to combat that at every level. And so that's why we're seeing a lot more of these occupancy limits restrictions on a state and federal level.
Yeah, agreed. That the idea is to encourage housing density in existing units rather than relying solely on the construction of new housing units in order to address this crisis.
All right, so enough about that. We're now going to talk about exterior siding. Well, loosely, more about paying for stuff. So the question is, when the HOA is replacing exterior siding and miscellaneous repairs that are required, but then it finds that the homeowner has various repairs that are their responsibility, what is the required method of payment? Is the association supposed to put the owners on a payment plan, which could get costly? Does the association require a 30-day notice for the payment? And we see this a lot. Some owners think the association is a bank, and in this case, the association is now over 20,000 in payment plans. So this question is too specific for us to answer. We have a lot more follow-up questions about what's the work being done? Is there a special assessment? Has the work already been done and paid for? Are you trying to fund it? When was the assessment due if there was a special assessment? Did you do the work before you told the owners that they were going to be responsible for the cost? How much are the owners responsible for? Who's responsible for what? All of these questions that make it so we can't answer specifically. But we can speak generally. So if there was a special assessment and an owner has not paid, you can treat this as any other delinquency and follow your collection policy. An owner failing to pay the special assessment on the date it's due is like an owner not paying their monthly dues. So you treat it, it's a delinquency, and you can follow your collection policy. You don't need to put people on payment plans, but you can if they're able to pay over time. That may make it easier to actually recoup the money, but you can demand it when it was due. If you have many delinquencies, it may be worth contacting your association attorney to take over collection efforts, because there are requirements for when there are delinquencies that the association must follow. So it has to do with like when you send out notice and when you can follow up on that notice and what the notice needs to contain. You also need to follow your documents as well as the statute for knowing when a payment is delinquent and when it's past due. So in terms of like the 30-day notice question, your documents, I don't know, they may say that a payment is not delinquent until it hasn't been paid for 45 days. That's a really long time, and it probably doesn't say that. But if that's what it says, you can't send a 30-day notice until after the 45 days have passed. So all that to say, contact your association attorney about that. But any assessment timeline needs to be reasonable. In some cases, 30 days may be reasonable. If it's a $20,000 special assessment, 30 days may be more reasonable than if it's a $500,000 special assessment. An owner's not going to come up with $500,000 in 30 days. I don't know who could do that, but in the grand scheme of things, it needs to be reasonable. $20,000 in payment plans is actually pretty small compared to what the association may have in reserves. We can't speak for your situation, but it may be that there are other ways to cover this instead of just taking on the debt. Valerie, do you have anything to add?
Yeah, one of the things that I wondered about when I read this question was, are we talking about a scenario where, I don't know, let's take an example. The association's replacing the siding, which means the windows should all be replaced at the same time, because doing those things separately is impractical and costly. But the owners are responsible for the windows and the association is responsible for the siding. How do you get the owners to pay their portion? And so I think that's a maybe potentially at least different scenario than a larger dollar amount where you're looking at 20 or 30 or more than that per unit, 20 or 30 grand or more per unit. In that scenario, like what Katie was talking about, a special assessment is probably the most practical way to handle the scenario. But if you're just talking about a few grand because an owner's got to replace 2 windows at the same time as you're doing the siding, then you ask, the thing is, projects like this do not happen without a lot of advance notice. If you're doing a strip and reclad of the whole building and you're replacing all the windows, you don't decide that 2 weeks before the money is due from the owners. That's going to be something that you're leading up to for months at a time. So you disclose as much of this information to your owners as early as possible and more than one time, so that it does not come as a surprise to them, so that they have time to plan for the expenditure, and so that you can then set a reasonable due date for when the owners need to pay the association, so the association can turn around and pay its contractor to do the work. So I think it really does depend on exactly what the scenario is, what the dollar amounts are that we're talking about. So the point of all of it, and Katie already said this multiple times, is we really can't give you an answer to this question here. Your association attorney, with the advice of, for example, your professional manager, if you have one, they can work together with you as a board to figure out what a reasonable plan is based on the specific scenario that you're dealing with. I'm going to jump into our next question. I am concerned that WUCIOA will place substantial burdens on the human and financial resources of our tiny HOA, fewer than 12 homes. Are there any exemptions from WUCIOA or RCWs for HOAs such as ours based on criteria like the number of units, amount of monthly or annual assessment dues, prior exemptions, creation date of the HOA, etc.? No. The short answer to this question is no. There is not an exemption that allows a small HOA to avoid being subject to the entirety of WUCIOA. The legislature is imposing more burdens on all HOAs because it believes it is serving a compelling public interest by doing so. And it may be true that that burden feels disproportionately difficult for a smaller HOA than it does for a larger HOA. And one of the things the Legislative Action Committee, lobbied for and was able to get successfully was more lead time in advance of WUCIOA becoming applicable to everybody in the state for exactly this reason, among others. We wanted to be able to get the information out there to all kinds of HOAs in the state. I mean, there's like 40,000 plus community associations in Washington. Most of them don't have law firms. Most of them are not members of WSCAI. Most of them don't attend this Q&A. Otherwise, there'd be a lot more than 59 people in here. And so we knew that we needed time for the educational push to try to get the information into as many hands as possible, that WUCIOA was going to apply to everybody. But there is no, especially for pre-existing associations. There are exemptions in WUCIOA for new communities. So if a developer is planning a new community, if it's a plat community that it's, less than 12 units, the annual dues are going to be less than $300 as adjusted by the statute, then there could be an exemption that limits the provisions of WUCIOA that apply to that community. But that exception is for new developments, and it doesn't apply to pre-existing communities that are going to be brought under the umbrella of WUCIOA come January 1st, 2028. You could contact your legislator if you want to lobby for that kind of exception. If you want the exemptions that exist in WUCIOA right now for new developments to be extended to smaller pre-existing HOAs, that is something that you could contact your legislator and try to advocate for, because we have some time before this becomes applicable to everybody in the state. There are some things that smaller HOAs may not have to do. So if your annual assessments are under $50,000, your community can vote annually. It has to do it every year to choose not to do the audit. That could save you a couple grand. And if you have insignificant common elements, then you might be able to avoid the reserve study. For advice on whether your particular community qualifies for either of those exceptions, you need to contact your association attorney. But the short answer to the question of whether there's a way for you to avoid being subject to WUCIOA at this time, there is not. Katie, did you have anything you wanted to add to that one?
No.
Okay. All right, I'm going to jump to our last question, and then we'll try to see if we have time to get to a couple from the chat. We are a small association of 18 homeowners. We have minimal amenities and therefore don't have high dues. Previous boards use our reserve money to fund projects, but never replenished the account. We are now severely underfunded and burdened with attempting to build our reserves up again. Without incurring increases in the dues that the homeowners will likely veto, can an assessment of an extra month's dues work? And do the homeowners need to approve the assessment? The board does not want to be held liable for neglecting their fiduciary responsibility. Okay. So I'm going to refer everybody to the conversation we had a little bit earlier today about why reserve studies are important, and not just getting them, but actually following them. The whole point of a reserve study is to spread the cost of major repair and maintenance out over not just time, but owners. So let's say you don't fund your reserve for 20 years, and then all of a sudden you have to repave all of the concrete within your community. The 18 people who live here now are the ones who are going to pay for that whole project. But maybe over the course of the 20 years that that component has been deteriorating, maybe you had 50 owners in that period of time. Failing to fund your reserves as you go means that instead of all 50 people that lived in the community over the course of that 20 years paying a little bit as they went along, the 18 people who live here now are getting stuck with the bill because they have to repave it. Otherwise, bad things will happen, whatever the thing is. So if you never raise your dues, you will continue to have this problem. I want to really specifically say that. We have some clients, I've had clients in the past where they would brag about the fact that we haven't raised the dues in 20 years. And I just I had to shake my head, and I had to talk with those communities about how they should be increasing the assessments annually, at least at a minimum, to keep up with the cost of inflation, if not the increasing cost of doing business based on the way other prices increase over time. And so if you do a one-time special assessment to deal with this issue now and you never raise your dues, you will be back in the same exact position in the future, because you cannot adequately fund your budget and your reserves without increasing assessments over time. It's not possible to do because the money has to come from somewhere. Whether you deal with this issue by increasing your monthly dues or by doing a one-time special assessment, you have to have that ratified by your ownership. There is no way to avoid the budget ratification process, whether you are increasing the assessments or whether you are imposing a one-time special assessment, in the amount of the 1 month of dues, like you mentioned in the question. The budget ratification process is spelled out in RCW 6490-525. And that process is required for a regular annual budget as well as for a special assessment. But a budget is automatically ratified unless more than 50% of the voting power in the community rejects it. So if you are proposing an increase in your assessments, or if you are proposing a special assessment, you send out that information that's required by the statute to your ownership. You hold a budget ratification meeting. You don't even call for a vote to pass the budget. You present the budget to the homeowners, and then the question that you ask is there anybody here who votes to reject the budget? And unless more than 50% of the voting power in the community raises their hand to vote to reject the budget, it's automatically ratified. So, I think that it's not possible to pay for work without collecting money from your homeowners. And whether you do it as an increase in the dues or a one-time special assessment, the money's all coming from the same place. If you don't increase your assessments over time, you're going to keep finding yourself in the same exact place with the same problem. And if you want advice if your documents, for example, seem to suggest that owner approval of assessments, in particular special assessments, is required, contact your association attorney so they can advise you on the differences between the statutory process for budget ratification and the language in your documents regarding that. Katie, did you want to add anything to that?
No, and I think we have time for like 1 or 2 questions, so I can take a stab at one that I see that I know will be quick, which is the board doesn't want to assign a board member to take meeting minutes. What are some solutions? The board can let the manager do it. They can ask the manager to take the meeting minutes that will then be approved by the board. But also be interested to know what your bylaws say as the secretary's obligations as an officer. Sometimes you don't need to assign a board member because the secretary is the one who's supposed to do it and prepare the minutes anyway, but the board can probably delegate it to the manager. If they don't want anyone to take minutes, that's a big red flag.
Problematic, sorry.
Yeah, so if they just can't decide or no one wants to volunteer, they could ask the manager to do it.
I think you could also delegate to a responsible non-board member homeowner. So let's say you don't have a professional manager, but you've got, let's say a spouse of a board member or somebody else that comes to all the board meetings who is responsible and pays attention to detail. Even if the bylaws say that taking minutes is the secretary's responsibility, I think that can be delegated, but it's ultimately the secretary who's responsible for ensuring their accuracy. And you have to remember the board minutes are the record of the decisions that the board has made in those meetings. And as we say often, probably to the consternation of many of our clients, if it isn't written down, it didn't happen. And so not having board meeting minutes is extremely problematic. And so at some level, what I would say is just because you don't want to do it doesn't mean you don't have to do it. Like suck it up and do it anyways. So that's my official legal advice, non-legal advice.
Also, board meeting minutes are a record that you have to keep, not
right.
for 7 years, not currently, but always.
Right.
And minutes are not as Jennifer came in, minutes are not a transcript of everything that was said, and they shouldn't be. Your minutes will be too long.
Yes. All right, and that brings us right to 11 o'clock. So thank you all for joining us, and we will see you back here next week. Bye, everybody.